Welcome to the Ansons podcast. I'm joined today by Rebecca Head, who is a Wilson Probate solicitor in our private client department. Welcome, Becky.
Thank you, Martin.
You know, I've gone straight in from starting Rebecca and then called you Becky straight away, but you go under both aliases, don't you?
I do. And of course, we did go to school together.
We did.
You are allowed.
So that is, calling you Rebecca just almost sounds too formal, but you go, professionally by both names. So actually, the introduction goes to sort of what I wanted to talk about, which is wills and probate. That I think pretty much most people will know what a will is. Maybe not so much what probate is, but let's get into it. The first basic question is, what is a will?
What is a will?
Yes. Gosh. Where there is a will, there is a way. But what is a will?
Or where there's a will, there's a relative, as we like to say in our team. A will is a legal document that enables a person to nominate who they want to deal with their affairs after they've passed away and who they would like to receive the fruits of their labour at that time as well.
Typically these days it would be a house or and the personal belongings and money in a bank account.
Exactly that. So all the things that people tend to own and accumulate
throughout their lifetime. And then just dealing with that as well, probate, what does that mean?
I get this question probably twice a week, every week.
Well, there we go.
And people often will say, what is probate?
Yeah.
The term, I think, is used to refer to a number of different things. So sometimes people talk about probate as the whole process of administering an estate. So from the point somebody passes away to the distributions at the end to the family.
That's like a generic title for what you do after.
What we do in terms of sorting all the estate out. But often specifically what people mean is the piece of paper that the personal representatives need to prove they are the right and proper people to administer the estate and to call in assets, to sell assets and to deal with the estate. So a grant of probate is ultimately a document that's issued by the court to say exactly that. These people are the right people to deal with the administration.
When I'm alive, I control my own bank account, my internet banking. If I want to buy a house, I deal with the bank, all of that sort of stuff. When I'm no longer with us, when I'm dead, clearly I can't do that anymore. And if I've got a will, the probate certificate or the grant of probate is the piece of paper that gives an individual the authority, the formal legal authority to deal with, to tell my bank what to do with my money, to sell my house and sign the contract. Yeah,
so if a person has a will, then that document gives authority to the executors that you've appointed to do those things. For certain aspects of dealing with the estate, you will need the grant of probate. If there is no will, and we are reliant on the intestacy rules, which are the legal rules that say, there's no will, this is what happens to the estate, this is who can deal with it, then we don't have that document to rely on, so you do need your grant in those cases to actually give that legal authority.
Okay, so in certain circumstances, some of the more minor stuff you can do actually just with a proper original will
with your death certificate and the will.
And your death certificate, and that would be presumably stuff like your current account that's got a few grand in it, or that sort of stuff. Or,
sale of chattels as well. When you've got a will and there's a death certificate, so simple things like that. And I've said chattels, and people won't know what they mean.
I was going to say, well, chattels always sort of conjures up to me. It's like a cow or a goat or something, but it actually could be a car, couldn't it?
It could be. It's all of your personal belongings. So there's stuff in your house, there's stuff in your shed, your car, all of those.
CD collection of Bob Marley would fall into it. If that's what you've got. That's a line from a song, but I can't remember who sang it. But somebody on eBay will accept that, won't they? I guess
you can sell on a death certificate. Yes,
your Bob Marley CD collection. Whereas if you haven't got a will and then a death certificate, if you've got nothing, then it's more likely that they're going to want you to have to go and get that grant of probate via the intestacy rules.
Yeah, so the legal position is the authority in that case is conferred by the grant itself rather than the will, because there isn't one.
And obtaining the grant, which I've seen one of them, I've seen several of them. On one level, there's no science to this. It's a piece of paper with a court seal on it that says so-and-so is Martin Dridder is appointed as the executor of the estate. You will need that, though, for most of the significant assets, right? You know, if I'm selling shares in a business or a house, right, a grant of probate is going to be needed.
Yes. So, again, this is a question that comes up. When somebody passes away, that's the first question they ask, do I need a grant of probate? And the good lawyer's answer, of course, is it depends.
Yes.
And it really very much depends what's in somebody's estate. So if there is a house in a sole name, absolutely, you'll always need a grant of probate, because no conveyancer worth their salt is going to deal with the sale of a property by a personal representative without proof that they're allowed to sell that. Shares in a business, absolutely, you need to prove title, and that's what the grant does.
I know where you're going with this, and of course, what you're going to say, I think, is if a husband and wife jointly own a property, is this going to impress you with my legal knowledge here?
It depends,
right? Provided they are what is known as joint tenants, and one of them dies, it passes to the other via the doctrine of survivorship.
Well remembered, Martin.
Listen, I'm an expert on law, legal AI, and the Law of Property Act 1925.
I'm impressed.
And the manorial system following 1066. Those are my four sort of mastermind topics. They're not, but that's a sort of not even. Is it a legal fiction? But it's how property holding is set up is that husbands and wives are assumed to sort of hold it almost as one. So when one of them passes, nothing really changes. It automatically changes to the other.
Yeah, there's still a lot of that arrangement around. Obviously, with the care fee plan type wills that we do, or wills for blended families where we've got two families that have come together, maybe second or subsequent marriages, then often that isn't always the case that they're joint tenants. They could also be tenants in common, where the property's held jointly, but we've got two separate parts to it, and then they can deal with their part in accordance to the terms of their will. So it's not always the case that married couples have a joint tenancy, because people like myself and my team often advise people to change that for good reason. But you're absolutely right. If you've got a very simple situation between husband and wife, all assets are joint, the property's held as a joint tenancy, it's unlikely that probate would be required in those circumstances where there's a will, because it's going to pass to the survivor. Generally, it's the second death of the party that we're doing, more of the grants and helping.
And it's absolutely needed.
Absolutely, because then, you've got assets in a sole name, they've got all the value in their pot, from that marriage, and ultimately there's more to sort out.
And in modern blended families, which is this really nice sort of lawyer's way of saying when people on to second or third marriages, but there are children from first and second marriages, perhaps that people would want to look after. Sometimes people have closer relationships with their stepchildren and step parents sometimes than their naturally born children. That's why a will's really important, isn't it? Because those darn intestacy rules are, on one level, the assumptions under that are old-fashioned. In some respects, it's primogeniture, isn't it? It flows down. It flows down the. Doesn't I think primogeniture might mean flows down the male line, but it flows down the familiar line, doesn't it? And there's
the intestacy rules are relatively outdated, I would say, because they just don't look at modern families. They don't take into account people who cohabit and choose not to marry, which is a huge proportion of our population now. And they don't necessarily look at stepchildren situation, because that is more common, much more common.
If I had split up with my wife, and if she's watching, I'm not planning to do that anytime soon. We're going on holiday on Saturday, so it won't be. It'll be afterwards. Even though I've got a little side quest planned during my holiday, which again I've got a very understanding wife, so divorce is not needed. I'll come on to that later on. The side, by the way, that sounds more sinister than it
really
is.
Does.
Walsall are playing in the playoff final, so by the time this comes up, so I'm flying back to go and watch that because I've been quite invested in that this season. But anyway, if me and my wife had split up, heaven forbid, and we've been apart for 5 years, I might even now by this stage have a new partner, but I haven't got a will. What happens when I die under the intestacy rules, typically?
Okay, so lawyer's answer again, it depends.
I get that, yeah.
It's always difficult to say because a lot depends on the assets that you've got in the estate. But if you still had a property that was in joint names, then potentially that might pass, as we've said, to the other one by survivorship. If, let's say, you'd separated out your assets, but you just haven't divorced and formalised that arrangement, then yes, if you were still legally married, the intestacy rules would say she would still be your next of kin in those circumstances. The bit that divorcing couples or separated couples really don't like is not just the fact that the partner might end up with these assets, but they don't like the fact that they're still responsible for your funeral arrangements, so they get to decide what happens to your remains afterwards. Which, if the relationship is not so good anymore, you might be on the bonfire somewhere.
Yeah, that's it.
It's a bit of a
basically put on the Guy Fawkes bonfire, 5th of November,
or over at Rugeley Tip.
Yeah, either place would not be where I'd really particularly want to end up. Floating down the canal on one of those sort of like Viking.
On your way to Valhalla.
Yes, sort of. Yeah, somebody's going firing an arrow into a.
Well, there you go, Martin. You need a will to put your wishes in it.
Oh, and I will do that. First of all, then getting a will is important, so you can be the master of your own destiny. You can write the script, as opposed to having a set of rules that were more or less have been in place for like hundreds of years.
Absolutely.
Determine who gets what. You can be the master of your own destiny. In terms of using a lawyer to obtain a will, to take your instructions and things like that can add value. Horrible sort of consumer, businessy type thing to say, but there is a value in getting a lawyer to take your will, particularly amongst the elderly. When there's, because you want to make sure that will that sets out your wishes isn't going to be challenged by one of those pesky relatives at a later date, don't you?
Yeah, well, of course I'm going to say that it makes sense to have a lawyer prepare the will, but yeah, you're absolutely right. And for a number of reasons, really. I would say, first and foremost, it needs to be right. Yeah. I have a friend and she always says, you don't know what you don't know. And I actually think it's such a simple phrase, but it's very true. Because, people can and do write their own wills. There are all sorts of options these days for not using a lawyer. But if you have a situation where someone writes their own will, how does that person know that they're covering things properly, that they're dealing with things properly? And if there are bits of law that they don't understand or they don't know, then it just won't be dealt with. So obviously using a professional is going to mean that we can have a discussion with people, see what they want to achieve, tell them if that's realistic as well, within the confines of the law. We can advise them about potential claims from these pesky relatives. Yeah. Because, say, for instance, somebody does want to cut a child out of a will, they need to understand the implications of that.
I was going to come on to that. I was thinking in particular, though, with the prevalence more and more as people are living longer of Alzheimer's and the dementias, the very different strains of dementia that can happen. One of the things that a lawyer is doing is determining whether that person has got capacity to give that will and potentially getting the evidence that might be needed to support the will in due course. Can you explain that sort of capacity side of your role? Yeah,
so in the law, one of the things you have to demonstrate is that you have the ability to make a will, that you understand exactly what you're doing, and ultimately that that capacity is present. So very much that is part of what we do. We are checking in accordance with, the proper legal test that the person in front of us has that ability, that they can satisfy, that they know what a will does, they know what they've got and what they know what claims that the family might have or who they've got in the family, so who they need to consider, and really that there's nothing causing them an issue, that they can't think clearly and they can't give you sensible and rational instructions. So that's very much part of our job, and really what we're doing before we do anything else is checking that that is present, because without capacity you haven't got potentially a valid will.
And were you, you're now what, 24 years into this? Longer? 25 years, is it?
Thank you for revealing that.
No one's aging you on this one. I'm not saying that you've got dementia, but but you determine that there's an element of that with your experience, when you've got an experienced solicitor taking your will, that they're reliant on the years of seeing different clients to determine whether they think there is a potential question of capacity.
Yeah, obviously, 20 odd years into this, I've got a fair bit of experience in terms of assessing capacity. However, there are certainly circumstances where we would absolutely recommend to clients that we also got some sort of independent medical report on their capacity. Perhaps if I've got a concern that maybe the situation is borderline, and I think perhaps, do they have capacity? Do they understand this? Or where somebody, and coming back to cutting people out of the will, somebody's making decisions in terms of a will that later on somebody else is not going to be very happy about. Yeah,
because then they go to somebody like me and I will write a letter to potentially challenge the will if in will number 1 my client was due to inherit half of the estate. In will number 2 it just entirely goes to my my sibling, entirely goes to my brother. My brother. If it entirely goes to my brother, then I'm concerned that did my parent have capacity at the time? They were struggling with this, that, or the other. Somebody like me is going to come along and write a letter asking you to demonstrate the evidence. I think I always get the first name of this case wrong. Is it a Clark and Lugas? I get these
Lark and
Nugas letter,
yes.
Which is in effect asking the lawyer to give some evidence as to the capacity.
To talk about the circumstances in which the will was made. And you're absolutely right. The first question is, did they have capacity? Because that's almost the easy one, isn't it, to say, they lacked capacity, therefore the will isn't valid. So part of our job, and coming back to your question about, why is it good to use a lawyer, is because we preempt this, we think about this, we see where the problems could be in the future, and we deal with them in advance by suggesting, let's get a medical report, let's write a statement to show why you're doing what you're doing, so that later on...
it almost sounds sinister, but we're creating the evidence to back the will up, in effect.
Absolutely. And I think people often think they come to see a professional for that piece of paper, but there's so much more to that, isn't there? There's all the advice that goes on around producing that piece of paper and making that piece of paper as robust as possible in the future. And that is very much, what our job is. It's to make it stand and give effect to the client's wishes, because that's what they want. And we try as best we can to make sure that happens.
There's another bit of law, and do you know what? As I say it, then it goes completely out of my head, but I know it's got the word miscellaneous provisions in there somewhere, whereby somebody can challenge a will on challenge a will generally on the fact that, not quite that it's not fair, but that inadequate provision has been made for a family member, which is yet. Go on, what's that?
Are you thinking about the Inheritance Provisions for Family Independence Act?
I did. It's not got miscellaneous provision.
There is a miscellaneous provisions one. I think it's the law of property.
I mean the 1975 one you just talked about.
1975.
Yeah, of course. Of course I am.
Because, again, that's something that you've got to give consideration to. When we're writing a will, we're asking people, right, who is in the family? Is anybody dependent on you financially? Do you make any financial payments? What are your circumstances? Because then we can take into account that piece of legislation and consider their circumstances and give them the best advice in terms of writing that piece of paper, because that piece of legislation says there are certain people who can bring a claim against your estate if reasonable provision hasn't been made. And it's a sort of a prescribed list of people. Reasonable provision is a funny issue, but, we have to, as will writers, explain to clients that certain people can potentially bring a claim, and we try and obviously head those off as best we can in advance.
And again, going to a lawyer to do that, make sure that you have considered and it's recorded that you have given proper thought to what provision those people have got. And that piece of legislation isn't a sort of a methodology just for courts to say what's fair or what's not fair.
Not at all, not at all. It's to recognise that there are people that may well have some form of claim on the estate. So we're very fortunate in our jurisdiction. We have something called testamentary freedom, which is a great lawyer's way of saying we can do what on earth we like under the terms of our will.
Yeah.
But then this piece of legislation simply says, yes, you can do what you like, but there are people here that you've got to consider when you're making those provisions.
And what would that be like a disabled child, perhaps, or even a partner that you've fallen out with who is financially dependent on you?
Yeah, sort of. It could be a child of the family. It could be somebody who's been treated as a child of the family. It could be a partner, an unmarried partner, somebody that you've lived with, you've shared costs with in terms of a household situation. The legislation, however, there's not a magic formula to say if it's this person, there's this much money, this is how long they've lived together, this is what they get. It's just a piece of legislation that says, right, we've got to consider these people, and reasonable provision may well be different in different circumstances.
And when you are taking instructions on a will, though, and what their assets are, a big part of that then actually is almost addressing what that act is there to do if you haven't done it, which is what is a reasonable provision for those members of your family, and identifying who those potential dependents are.
Yeah, and just investigating that position and saying, okay, you've mentioned this person, we need to talk about that, we need to understand what the circumstances are, and then we can usually, because of years of experience, give them a bit of a steer on what a court probably would say was reasonable provision for a person in those circumstances, and that can help us formulate the plan in terms of the will to avoid claims in the future.
And a ChatGPT will is just not going to do that, is it? Yet, at least.
Not on the current form I've seen.
No.
I did a bit of an exercise some while ago, because there's lots of online providers for free wills.
Yeah.
And I did an exercise of putting my own circumstances into it and asking it to produce a will for me.
Oh, interesting.
Because I thought, well, let's have a look, is this useful for people? Will it get it right? And the very interesting thing, so I did this will before I married. And one of the big issues we have in law at present is that if you marry after the date of a will and you haven't put a clause in your will to say, after I get married, I want the will to still stand, the will automatically gets revoked. Nowhere in the online questionnaire that I did to produce my will asked me the question of whether I was about to get married, which I was at the time. It was about a month away. Nowhere in that online question did it ask me about the value of my assets, which I knew at that point my estate was taxable to inheritance tax as a single person. I knew that, but it didn't ask me that. And the will it produced was a will that I could have signed, but it would have been revoked by my marriage, and it really wasn't tax planned very effectively. And of course, you don't get any advice, do you, on that? And it comes back to, why do we use professionals? Well, we use professionals because I can tell you that. I can tell you, oh, we need to be aware of this. Looking at the value of your estate, you might have a tax issue, but we could do X, Y, and Z and improve that situation. Yeah,
I mean, we will bring, we've had this in other areas of law, and the people that we've had on from the family lawyers and even some of our property litigators, that one of our jobs is sometimes is conducting the orchestra of other professionals, and to sometimes bring in independent financial advisors and in particular accountants, right, to assist with tax planning. On one level, for a single person, the inheritance tax threshold, it's not massive. The price of a house, certainly in somewhere we've got offices in Lichfield and around our Mere Green office, houses can...
Well, $500,000 for a house in Lichfield is probably a fairly average property.
And the inheritance tax threshold was...
For a single person with no children, $325,000.
Yeah. So...
Which is incredibly low, really. But, of course, that is frozen. The government said in the last budget until 2028. So
it's going to pull more and more houses in different areas into the inheritance tax.
Absolutely, and with the changes to the pension rules as well, there'll be an awful lot more people paying inheritance tax.
Yeah, because for many years in pensions and pension pots, because they were a trust, did not fall inside the inheritance tax rules, but they're going to.
Yeah, so they were treated as being outside of the estate for tax purposes, but the rules are about to change and certain pensions will be pulled into the value of people's estate.
And I think that what, at one level, sort of the financial advisors for a number of years were saying to people, well, leave your pension pot over there, spend your money from your savings and your ISAs and everything else, because they'll fall into your taxable estate. Leave your pension pots over there. But these days, it's not quite yet, is it? There's a transitional period, but that advice is going to change. In the pension pot, you should be spending now up to a certain point, or at least dealing with it, with being aware of the inheritance tax consequences. Right?
Yeah, I think with the upcoming changes that were announced in the budget, there's talk of the great wealth transfer happening, and I think that will be something that's on the cards for a lot of families because they're facing an inheritance tax bill that they wouldn't have been, and they now need to think about planning. It
reminds me of the plot of the film. Was it Brewster's Billions or Brewster's Millions? Was it inflation? Did you know the film I'm talking about? It's like a Richard Pryor film, and he's got to get rid of. I can't remember if it can't be $1 billion. Maybe it was £1 million. He's got to get rid of within a month, but he keeps spending it on stuff like he goes to the casino and he wins.
He wins more, yeah.
And I think he ends up buying like the New York Yankees or something along those lines. And whenever he's trying to spend his money, but it keeps getting more and more. It's quite a funny film. I would recommend it.
Thank you.
Yeah, no, there you go. But that is not financial planning advice, may I hasten to add. But we can refer people to those professionals who can help with that aspect of it.
Yeah, the private client team as a whole, we work very closely with
a number
tax advisors, financial advisors, accountants. And I think we will be even more closely working as a team for our clients when all these sort of inheritance tax changes are happening.
Yeah, we've had on some of our corporate team recently and some of our property team, and clearly for people who own businesses, a lot of the advice or the traditional advice has changed. Historically, if you owned a business and it was a trading business, not just a collection of property assets, the advice would be, and for farmers, die with your boots on, because you will get 100% relief in terms of the agricultural property, and also if it was a company, the business property. But with these changes, that's no longer going to be the case. And on one level, passing on, doing that transfer of ownership sooner in your life is going to be, it's changed, and that's going to be encouraged now,
It's
right?
coming back to that great wealth transfer.
Yeah.
Absolutely. And that's the one thing I would really encourage people with the trading businesses, with the farms, talk to your wills solicitors, talk to your solicitors, because, if you've got a will, particularly that just leaves everything to your spouse,
it's not very tax efficient anymore,
really
right?
going to be a problem. We need to do some planning for those people to make sure they make the best use of all the allowances that will be available when the rules change. So, people could lose £1 million worth of allowances if they've just got a very basic will that leaves it all to the spouse. So we need to do some planning for them.
Yeah, I was just going to say the trick being to the trick's the wrong word, but leaving maybe £1 million worth of those assets to your spouse and gifting some of the rest is could well be part of the consideration. I'm not giving that advice, by the way, here on this podcast.
Good, because that's not quite right.
Okay, good.
Don't give that advice.
Okay.
But yeah, absolutely. What you don't want to do is allow the allowance part that would be available to pass to the spouse, because spouse exemption would override that allowance.
Right.
And on the basis of the rules that we are seeing at the moment, it doesn't look like that allowance is going to be transferable between spouses, so it will be lost. So what we need to do is, and I think where you were coming from, was try and force the use of that allowance on the death of the first one of them.
Right.
And that could be by leaving assets to the children if that's appropriate, or it could be utilising some form of trust if the surviving spouse needs some access still to that.
Of course, that was what I meant. But
Exactly.
even more
Well
pertinently, you go and see, an expert rather than, and rather than your friend down the pub or your dispute lawyer. Go and see a wills and probate professional.
There's a lot of blokes down the pub and ladies at the hairdressers that scupper me day in day out because people come in and say, the lady down the hairdresser said this is what I need to do. Although the change is now, my daughter saw this on TikTok. That's what I'm dealing with at the moment. Some of this is on TikTok, by the way. Well, maybe if somebody comes in and says, I saw Becky on TikTok, can you come and do this? I'll take that.
Hashtag lawyers of TikTok is one of the.
I'm not twerking, Martin.
There'll be no twerking, no TikTok dances until the end of the episode.
And I'm terrible at jacket potatoes as well, so I'm not spud manning either.
Yeah, I like it. I like a jacket potato, though. Do you? Go on, give me your top 3 jacket potato. I know you're vegetarian. Give me your top 3 jacket potato toppings.
Cheese and coleslaw.
Okay.
Bean chilli.
Bean, and are you combining beans and chilli, or are you saying beans?
No, a bean-based chilli. I know that doesn't sound exciting to a meat eater, but a bean-based chilli.
No, I like a vegetarian chilli.
Just plain old cheese.
On its own?
Yeah.
Bit of pepper?
Bit of black pepper.
And how are you ranking those? How are you ranking?
Cheese and coleslaw is top.
Right.
Maybe then cheese on its own with the pepper next.
Yeah.
Bean chilli number 3.
They tend. The only thing I would say about other than Spudman, other jacket potato providers are available. They're just not as good. I think with a chili, or indeed the curry that you get from those people. From the Spudman type people, they're always I guess again for a max audience, they're not spicy enough for me. I never find. I think they're maybe a bit sort of middle of the road in terms of those fillings. Really,
I suppose they have to appeal to the masses, don't they?
Don't get me wrong. I do like a chili topping. That would probably be my favourite. Definitely would be the top. Then maybe curry. And then beans with cheese on top, like baked beans with cheese on top, which I think is, your traditional old favourite. Moving on from jacket spuds to, and actually moving on from wills for a second here, the power of attorney. What's one of those?
Okay, so a power of attorney is a legal document that allows a person to nominate another person or a number of people to be able to deal with certain aspects of their affairs. Mm-hmm. So what we deal with a lot in our team are lasting powers of attorney, and there can be one for property and financial affairs and one for health and welfare, and they do very different jobs.
Okay.
Property and affairs very much does what it says on the tin. It lets the people you choose make decisions and help you with dealing with your finances, your home, your bank accounts, your investments.
Gas bill.
You've got it. All of those kind of interesting things that we all have to do every day. Health and welfare, very different. That is about the person and their sort of welfare, really.
Medical needs and
where you might live, how you might be looked after, operations. It can even cover decisions about end-of-life care and whether you want treatment or you don't. So very different in what they do, but basically the same in the sense that they let you appoint somebody to help you with those decisions if you get to a point where you either can't make those decisions or you need support.
But that's important, isn't it? Because in the same way that you need to have capacity to give a will, you need to have capacity to give a power of attorney to somebody, don't you?
Yeah, absolutely. I think people often say to me that lasting powers of attorney are just for the elderly, but they're really not. They're something that people need to consider while they're in good health as part of their planning process, because you're right, you've got to, like with the will, understand exactly what you're doing, what this is about, who you might want to appoint, who thinks they ought to be appointed, and who the right people for the job are.
I mean, I have said internally in Ansons that, certainly, and perhaps it's younger than this, but like anyone buying a house over the age of 50, our clients, we would be really helping them by almost strongly suggesting to them at the time they buy that house that we refer them into your department to get that power of attorneys, because once you're over 50, chances of things happening like strokes and heart attacks or... What is
it they say for men over 50? They call it Sniper's Alley, don't they? Is it between 50 and 60 something?
Oh, Jesus, I'm not amazingly far. It's my birthday this week. I'm not amazingly far off the Sniper's Alley now. And these days with medical science, people don't die, right? But they might.
No, we're all living a lot longer, aren't we, than our ancestors ever did? But then are facing ill health, that decline in our health because we're so much older, and also a decline potentially in capacity as we get older as well. But yeah, I would say powers of attorney are important for everybody to consider, not necessarily just people over 50. Obviously, I think as we all start to get a little bit older through our lives, we start to worry about it. But think about business owners, much younger business owners. What happens if, they haven't got a structure that the business could carry on if they lost capacity? How are we dealing with that? They might be much younger. But yeah, I think this is planning that should be done long in advance, like wills, really. We get a lot of crisis purchases with wills and powers of attorney. And none of us like doing that. It's not easy. It's much easier if you think about this long in advance.
Time to breathe. The instruction almost gets time to breathe.
Absolutely. And we can have, a nice chat about it. We can make it a nice process rather than this really needs to be done and we haven't got that much time to think about it or to make decisions. But yeah, anybody really that's got any sort of assets. I was chatting to a financial advisor recently and he told me that they'd had some difficulty with one of their clients, husband and wife. Husband I think he'd had a stroke or something similar to that, and he was in quite a poor state. Fortunately, one of the sort of the policies that he'd taken out paid out, and it was going to pay the mortgage off. The policy was in the husband's name, but now at the moment he's lacking capacity to claim that. So the wife was struggling to claim the policy, and it was becoming very, very stressful. Had there been a power of attorney, not a problem. She could have claimed that if she was the appointed person, or the people they'd appointed could have claimed it. So really anybody can benefit from these.
I think that if you take anything away from watching this episode, getting a power of attorney in place is so important, and we would recommend that, more or less, everyone, certainly middle age onwards, and if you consider yourself that, you probably need one.
Or anybody really with assets in that sense. I think Martin Lewis is doing a lot for the powers of attorney cause. Yeah. And he says he feels they're more important than wills.
And I can see.
I would argue both are necessary, but absolutely.
Just sort of in the slightly myth-bustery way that sometimes we address things on this podcast. Going back a few years, there was some rush for people to get a type of a power of attorney that they were abolishing, the enduring power of attorney. What's that? And then and that no longer exists, does it?
Yeah, when you say some years ago,
go on.
My clients laugh at me because I still talk about the new system.
Okay.
And the new system, 2005, the piece of legislation.
Oh, was it? Well, when was that?
So the rush you were talking about was the end of September 2007.
Okay, yes. So, I remember that.
Yeah, so...
Fondly.
So what happened was, you're absolutely right, we used to have a slightly different system.
Yeah.
We didn't have lasting powers of attorney, we had enduring powers of attorney, and the changes were coming.
Yeah.
And they were so very different to the old system. They were a lot more cumbersome. The process seemed to be becoming more cumbersome, and the costs of things were obviously naturally going up with the complexity involved. So everybody panicked and got everything done before the end of September 2007. And I also remember it well, and not quite as fondly, I'll be honest.
No. I was a litigator, so I didn't really have to. I might have had to certify a few things.
I had tonsillitis and lost my voice the last week of September, but still worked to make sure everybody signed everything. What a trooper.
Yeah, what a trooper. I was about to use that exact phrase. Talking about things that have changed in the past, There's some proposals now. The government has got there's some law commission report out about changing things in this sector. That's been announced in the last sort of month or so, is it? Or last couple of months?
Last Friday, the report was published.
Right.
And huge changes are recommended across the will sector.
What are they?
Well, Martin, the report is 500 pages long.
Okay.
And as it only came out on Friday, I'll be honest, I haven't read all 500 pages. I've read about 250. I've done quite well.
Oh, that's pretty good.
So I can give you some of the headlines.
Go on. What are they?
I shan't bore you with everything, but there's a couple of standout things without a doubt. So one of the big ones we've already mentioned, that if you marry after the date of a will,
right,
and you don't have a special clause in it to stop the will being revoked, then basically the will gets revoked. The Law Commission report is recommending that is abolished.
Good.
So actually, it doesn't matter that you married after the date of the will, it would still stay in place. And I think, yeah, you're right, practitioners are welcoming that, without a doubt. In the last, probably since about 2017 or so, there's been huge talk about predatory marriage, where people sort of swoop in to the widow or the widower, sort of whisk them down the aisle.
I've been involved in cases where that's been alleged.
Yeah, become the next of kin. The will gets revoked. They then inherit under those intestacy rules that we talked about. There was a huge case, you may have seen it in the media. Daphne Franks was the lady, and her mum Joan Blass. And she has campaigned tirelessly about predatory marriage because it happened to their family. So I think that's been very much taken on board, and by changing the way the law operates, it will probably then take away the benefit of predatory marriage.
What, by giving a right similar to similar legislation to the 1975 Act that gives that as a grounds of challenging a will or revoking a will?
Just to say that the will no longer be revoked by reason of the marriage. So
okay.
That's the recommendation. So it just reverses the legal position.
Right. So it would have revoked the will, and then under the intestacy rules as it stood at the moment, if you got married, you got all of the assets because the previous will had been revoked.
And there's also a really weird quirk that we talked about capacity, but capacity is different for different things that you do. The way I always explain this to people is, if someone said to you, Martin, do you want to wear a green jumper today? You could very easily take a view about that. If I said to you, Martin, do you want to sell your house and invest all of your money in Japanese venture capitalist shares? It's a very different decision.
Yeah.
And with...
just answer though, green jumper, if it's XXL, yeah, wear it. Japanese shares, no, not for me.
Excellent. But so from a point of view of a will, there is a level of capacity. For a point of view of getting married, there's a level of capacity. And bizarrely, the level of capacity to get married is much lower than to make a will. So one of the issues with this situation of the will automatically getting revoked is somebody could have capacity to marry, but not capacity to make a new will afterwards. So that causes all sorts of issues. So the changes that are recommended are absolutely welcomed. I think it will really take away that incentive for predatory marriage as well.
Well, that's definitely something.
That's a good one.
Welcome.
Another one that they are recommending, and this is of course the big one, and it's a hot topic, isn't it? Really, particularly after COVID and the way we all had to change the way that we worked. Electronic wills.
Yeah.
At the moment, the accepted method is a paper will.
Yeah.
And you sign it, and the witnesses watch you sign it, and that's how it's done.
And you have to keep the wet ink. It will have dried by the time it's been used, hopefully. But you have to submit to the probate registry the actual original document.
Yeah, absolutely. So the Law Commission report recommends that electronic wills should be a viable option in the future. Obviously, we're not sure how that will look, but it's really interesting. Their view was a lot of practitioners and professionals are concerned that there might be abuse, there might be safeguarding issues. We've got to make sure the person signing the will is in fact the person signing the will. We've got to make sure there's no undue influence. Somebody's twisting Granny's arm up the back to do it. Press this button here, Granny, suddenly you've got a will. How do we check capacity? All of those issues, and they acknowledged all of those issues in the report, But what they said is this is coming regardless. We've got generations below us that they don't know any other way of dealing with things other than through technology. So we've got to find a way to do this.
And also the evidence that somebody has signed it in certain respects, your digital footprint via your phone, or when you DocuSign, other products are available, but when you DocuSign a document, it's pretty indisputable evidence that person has signed it. But I guess if you don't see them, perhaps somebody signed it on their their device. I guess is be the problem.
Who is the person making the signatures? So there's recommendations for this to be enacted down the line, and one of the things that they were recommending was that the legal formalities should be similar to that of a paper will. Right. We shouldn't do away without the pomp and ceremony, because that's actually quite important. It's important because it makes people recognise this is quite a serious thing to do. They need to think about it. And also it enables us to make sure we have got those safeguards in place, we have got those checks in place. And interestingly, in the report, it mentions various sort of electronic signature providers and software providers who demonstrated how this could work to the Law Commission. And that was interesting reading. It really was.
Because some of that technology, even though I've just said what I've just said, some of that technology, if you've got copies of people's signatures, and they've signed other DocuSign or whatever they provide as documents, it's pretty...
Could be very
good evidence.
Forge, couldn't it? As well,
maybe. And there's part of me that can see come in using software for, online conferences and whatever else. You can see a situation where Wilson Probate solicitors are required to film, to record and film their
and
meetings.
Actually, that was one of the things I think that were demonstrated to the Law Commission to say, actually, we've got to have a system where we can link that person making their signature to the signature on the will. There needs to be some sort of check and balance on that. But also, potentially, there could be a situation where we also record that. We make a video recording of that, because then we can show it is that person. And that might add greater evidence as to capacity, as to the fact that they're not being unduly influenced by somebody else, and record that procedure. What the Law Commission report doesn't do is it doesn't want sort of video recording wills like there are in some jurisdictions, or audio recordings, with all the issues with deep fakes and things like that.
Where you interview somebody on their deathbed and that would become the will, that video becomes the will. They don't want that.
Yeah, they don't want that. But what they were not ruling out was potentially, a way around making sure it was the person, was some sort of video of that happening as well, and it could all be tied in with the same software. So it makes very interesting reading, and I have to say, quite excited about.
Anything that makes it easier to get that part of it done, right?
The figures I was recently reading said something like 35 to 40% of the population have got a will. Why are the other people not making wills? We know they're important, but why aren't they doing it? And I think the more barriers we can take down to people making wills and doing the right thing for their family, the better. And the more options we can give people, the better. There'll be a whole raft of people who don't want to do things that way, but actually there's a whole raft of younger generations potentially that have grown up knowing nothing else and do want to do things that way and would expect to do things that way. So that's quite exciting for me to think about, that we'll be looking at slightly different markets and talking to different people and be doing things in a really different way. The wills legislation that we've got is from 1837. So these recommendations are long overdue, because life in 1837 was very different.
Well, your chattels, as you mentioned back then, literally would have been like a horse and a cart or something like that.
Quite, absolutely.
Or a green jumper, but probably not Japanese cryptocurrency shares.
It would have come under, I think, the 1925 Act that said cloths and linens and things like that. Motorised vehicles, self-propelled vehicles, horses and carriages.
Do you know it's the 100th anniversary this year of the Law of Property Act? And what are you doing to celebrate?
I might have a jacket potato with cheese and coleslaw.
I think that is what the drafters of the Law of Property Act would have wanted. Well, listen, Becky, Rebecca, thank you for coming on the podcast today. I think when we get a little bit more detail on the new legislation, if you could come back on and we can discuss that would be brilliant. But thank you for today.
I'd love to. Thank you.